item number 2, hearing number 09-14, City of New Orleans versus S Express Food Store, LLC, doing business as S Express Food Store. The city is ready to proceed.
Let me get these out.
I believe, do we have a motion to continue pending on this one? Thank you.
Yeah, Ed Washington on behalf of S Express Food Store. I filed a motion to continue, I guess, for 2 reasons. Once the first one I was in jury duty this morning. I wasn't sure when I was going to get out, but I got out about 40 minutes ago. But more importantly, the second one has to do with discovery matters. I haven't gotten a lot of my discovery responded to, or else it was denied. I requested safety and permits file. Yesterday I got about 4 pages of a printout late yesterday afternoon. I requested the finance file, the Department of Finance file, and I have gotten those finance file materials before, but this time I was informed that there's a right to privacy issue and I can't get any of it, even though it's my client's file.
When did you initially request the discovery?
I think in October, like mid-October, October 16th. I did a first set of discovery about October 16th, and then I did a couple of follow-up requests. But so what I did, and some of my responses were that the information is not relevant, this, that, and the other. So I followed that up with a public records request on November 3rd, because under the public records laws, relevance and attorney-client privilege is not relevant if it's unless it's prepared in anticipation of litigation, and it's not prepared in anticipation of litigation until litigation begins. So. And that was about November 3rd. I did the public records request, and I haven't gotten a response to my public records request. So,
is there an objection to producing the documents he's seeking, Mr. McNamara?
Some of the documents he can get because they're his client's records. His client can go down and get those, their records themselves. There are some issues with that he was asking for certain tax returns and stuff like that. That without something for his client showing that we can produce those stuff. You can't produce that stuff. That's private, privileged information. He can go down there and bring his
client's taxes?
That's correct. So he can go down there to the finance department, bring his client down there at any time and get those records. But having said that, again, all those materials, the finance records, are wholly irrelevant to the proceeding that's before this board today, which involves the improper issuance of the high-content alcohol permit. There's all that is irrelevant to the proceedings, and we have provided Mr. Washington with those relevant documents, and we have responded to all of his discovery requests.
Well, I mean,
we're talking about one piece of paper, one witness, and we're done with this hearing. The rest of this is just...
I mean, the records I'm seeking, the finance department file tells me when the permits were the high-content permits were issued, how long she had them, whether or not I have certain grandfather arguments, the sales tax, how much she's spent, and I can't just go. I mean, yes, I can go and talk to him, and sometimes I may be able to see him, maybe not. But the city, when you do a public records request and they respond to you, they warn you that we claim everybody as our client. And, in certain pleadings, I don't know if it's in response to public records requests, but when I file pleadings, the city, sometimes they have boilerplate language. We warn you, we claim that everybody is our...
I'm at a loss as to what Mr. Washington's saying right now. He's been talking for a good while here without saying anything.
What time period would you allege that your client would be grandfathered in?
It would be 5 years.
So during the hearing or the trial, if it came out that it was 5 years that they've had it, then you may win as a right, correct?
Yes. Well, the city's action may be prescribed.
Right.
Right. But I mean, there's other theories of law. There could be a detrimental reliance issue, depending on how much sales were made or how much revenues were generated from the high content alcohol during the 2 years that they've had the high content permit. There's an issue. There's an issue.
I'm sorry, I didn't understand your question.
Have you filed a counterclaim for that based on that information? That there may be detrimental reliance?
Not yet. I need to see the files to see.
I think the reason is because that just doesn't exist. Mr. Washington knows that doesn't exist. This is just obfuscation. And when we call our witness, that will be made perfectly obvious as to when the mistake was made and when they were issued a permit for.
Okay, let's do this to circumvent it. Mr. McNamara, will you please just give him the permit information that he's seeking pursuant to his discovery request? Mr. Washington, you had filed a previous motion to continue because you were in jury duty, and that was granted. So
Okay.
it'll be reset to the December 16th hearing, but it will be tried on that day.
Okay.
Any other comments?
No.
I understand. I've got comment cards. If you need to speak, did you fill out a comment card?
I did.
Okay, it'll be called in just a second.
I wonder if she's speaking about this.
Yes, she is. Or someone is. Are there any other comments from the board? Okay. I have a comment card from Kate Lowe.
Can we change the order?
Is this not for 0914?
It is, but there's other speakers that have also asked to comment, and I would like to allow that.
Okay, the only other card I have is for Greg Jeanfro.
I gave, I don't know where the clerk.
Comment card?
We all get cards.
Okay, do you have cards? Are they over there on top of the piano?
What did I miss?
Ma'am, what's your name?
Sarah Stogner.
Okay, Sarah, and Mr. Jeanfro, you're yielding your time to, okay. You have 5 minutes.
I have a procedural question first. Is there a way, I'm an attorney and I'm on the board of the Neighborhood Association. Is there a way for us to formally intervene into these administrative proceedings so that we have an opportunity to speak when the attorneys speak?
Yeah,
I mean, yeah.
there is. You can file a motion for intervention.
Okay,
Yes.
I don't practice this type of law, right? This is on a pro bono basis.
Just for a point of information, under the Chapter 10, any citizen of the city has, or any party has a standing to bring an issue before the ABO board, so that they would in fact have that.
But this is a pending matter, so she doesn't need to bring a new matter. She can just file a motion to intervene.
That's correct, I believe.
Okay, thank you.
Welcome.
Can I orally move to intervene at this time, or do I need to file a written motion?
File a written motion, please.
Okay. I just want to say that we object to any continuance. It's a delay tactic. They are selling high content alcohol. They've come, they've spoken to our board, they've spoken to our general neighborhood association. They have refused to stop selling high content. Everyone agrees that this was a clerical error. I have a copy of the permit issuance date. I was able to receive it. I made a public records request back when this first came. I have a red rope full of documents that we've received. If the neighborhood association has timely received the information that's relevant, I suggest that the information that the S-Express is now seeking is information that is just as available to them. If they're looking for their sales, their net revenue, that's all information that they generated from their sales. There's no reason that they need to be going and getting that information from the city or from a third party. Is there any way that we could request that you guys at least suspend their ability to sell the high content in the interim as they continue to delay? It's a detriment to the neighborhood. We have bad actors hanging out. We have people, illegal activity is going on. It really is a nuisance to the neighborhood.
Yeah, I think we can entertain that. We'll open the floor for discussion between Mr. McNamara and the defendant's attorney about your issue.
Okay, thank you.
Thank you. Mr. McNamara, would you like to chime in on that?
I mean, I'm certainly fine if they would like to. I'd be happy to do that and have them suspend their high-content alcohol sales. I have a feeling that Mr. Washington is probably not going to acquiesce to that. But again, just reflecting what Ms. Stogner said, that's in fact the case. Is this is not an unknown issue. There's one issue here, and that was the one mistake that was made. It's a documented mistake. It needs to be corrected. And the rest of it is just, obfuscation and trying to put off the inevitable, which we believe it would be coming if we were allowed to put our case on.
Okay, I'm looking at this LAMA license summary. Is this I'm not sure how
That's
I got
the llama. That's the city's llama system.
Okay, and The application was filed, it looks like 3/11/2013. Approved the 13th, and it expired December the 13th, December of 2013. I'm just not sure what this is telling me. Can you?
And Dr. Munster's here and who could talk about that. I don't know which copy of that are you looking. I'm looking at the same thing, but my copy is a 4-page document, and this is what Dr. Munster would be testifying to on that. And there's the approval process that goes through LAMA, and then the permits are actually issued through the Revenue Department.
Mr. Washington?
Oh, well, I guess as a matter of procedure, I also filed a motion to dismiss based on the
Yes, we don't want
the failure to file a police affidavit, and I also have a motion. I think it's a prematurity based on the, and y'all discussed it before, but based on the failure to basically issue what's equivalent to a notice of violation prior to instituting formal proceedings. So I think procedurally, if you want to address those are two.
So if Mr. Washington wants to address that prior to us going into the formal procedures, I would ask that you.
Well, I think we've actually, maybe not in this particular case, but we've addressed those issues in the past in several matters, and those exceptions were denied.
That's correct.
And I don't see why my opinion on that would change. My fellow board members may disagree with me, but I will deny both those motions. Any discussion about the issue currently before us about the recommendation of suspending it until the next hearing? No. Mr. Spear?
I mean, are the parties willing to agree to that suspension?
Of the permit?
Yes.
Well, no, I mean, no, not at this time. I mean, this whole issue is, I mean, this is a petition to suspend and revoke, and our main thrust is that we haven't been provided with information sufficient to put on a defense. I mean, I'll give you an example. In a request for production of documents, we requested production of the safety and permits file, and the response was, the city will produce the file when the defendant requested. That was the response.
Mr. Washington was provided with the documents and connection.
And so yesterday I got the 4-page late,
with that.
and that was requested in mid-October. And
We also offered
late
Mr.
yesterday
Washington
afternoon,
an opportunity to
I got
come
a
and
response.
inspect our
Let
files.
him finish, please.
And late afternoon, I got a response that I think you're looking at that kind of deals with maybe occupational licenses and not necessarily alcohol licenses. But the response was to a request for production of documents that they're going to produce it when I request it. And so, and my other request for the finance department file, there's a right to privacy for the file. And these are just the basic foundation, basic information that I need to begin an investigation and review of what my defenses might be. It's just a fundamental, basic starting point. And
When you say that, so are you saying when you come in December, you may not be ready to go forward because you haven't finished investigation?
well, no. I'm expecting to be provided with the information I've requested. I haven't been provided with hardly anything, and I'm expecting to be provided as a result of this hearing and your instructions to provide me with the information I've requested and the information to my November 3rd Public Records Act, which the city, should respond in 3 to 5 days or a reasonable time, in which I've gotten no response. But I've gotten a total of 4 pages to numerous, to 6 requests for production. I've gotten 4 pages.
And those 4 pages are responsive to his request for production of documents. I don't know if that was the only thing that and again, this is a very simple issue. Mr. Washington is here suggesting to you that things that were going on prior, that his the 5 years, all this stuff, when I'm sure if you've even had a 2-second conversation with his client, he knows that that's not in fact the case. So again, what he's trying to do is these are dilatory tactics. This is a very simple case. This was a permit that was issued in error. We have the information relative to that. You can make a determination whether it was issued in error without any of this other information whatsoever. We have Dr. Munster here who's ready to testify. We would like to proceed.
While, you know, if it is accurate that there is no permit and they're selling high-content alcohol, then obviously that's an issue. But without the facts being presented to us, unfortunately, I don't think we can ask them to not serve or not be in business for 30 days because it's unfair, as much as I hate to say it. Mr. Washington filed a motion, submitted information that he was in jury duty today, which was the basis of the continuance. That being said, if someone on the board wishes to make a motion,
Well, I have another question. When does your jury duty end? So next time we don't come.
Oh. Well, I found out, I mean, I called yesterday and asked them about it, and I was told to report today, and I have to report again on Thursday, and then again the following Tuesday.
That would be it?
Unless I get selected. So I expect that to be it. But that's, you know, I was released today at about 12:15, and I had to run back to my office and run here. But you don't know until, you know the process.
I'm sorry, Mr. Washington only learned of his jury duty yesterday? Is that what he's suggesting to this board?
No,
Okay.
I called Monday and asked them how long, and I told them about my ABO hearing and asked them, will I be there until 1 o'clock? And they responded, well, we're not sure. If you're picked, you may be here the whole day or you may not. I called to verify.
One thing, Dan, if indeed they're selling alcohol illegally without a permit.
That's not the suggestion. The suggestion, the basis of the case is that they were issued a permit in error for high-content alcohol.
Okay.
Yeah, they
So,
presently have
it's
a
not
permit.
sir, if you need to speak, you have to put a comment card in.
Yeah.
Okay.
So the issue was that there was an issue. There's a permit that was issued in error, and that's the
So they have a permit. They're just
right, and they've had it
generic.
for. And this property is in a historic district, so if they had been, you'd have to have not, as Mr. Washington says, some kind of 5 years without the city taking any action. You'd have to have 10 years without the city taking action. But regardless, either way you slice it, that is not what is in fact the case here. And that again, I think we're just delaying the inevitable.
Okay. I'll continue taking speakers. Conrad Abity.
I'd like to say right up front that I think it's extremely unfair to a neighborhood that's had to fight this battle over and over again. I was here in the fall of 2007. In order for them to get a high liquor content license, they required a zoning change. The underlying zoning change is two-family residential. That has not changed. Okay? So they applied for a zoning change in order to get a high-content liquor license. They can serve beer. That was grandfathered in. The store is grandfathered in. But in order to get a high-content liquor license, they needed to get a zoning change. Went through City Planning Commission in the fall of 2007. City Planning recommended no. They were turned down at City Planning. They appealed it, which was their right, to the City Council. In October 4th of 2007, zoning docket number 8507, the owner, Audrey R. Saladino, requesting a zoning change from RD2, two-family residential district, to a B1 neighborhood business district and a conditional use permit. The sale of alcohol beverages for consumption off premises for the square 352 Lot A in the second municipal district bounded by Ursulines Avenue, Orchid, Crete, North White, municipal address 2703 Ursuline. The recommendation of the City Planning Commission being for denial. Speakers, proponents was Dolores Walker and Ricky Soprano, who was then the lessee, and I still think has something to do with this one. Opponents, Conrad Abity, that is me. I live at 2909 Grand Route, St. John. There was discussion. Councilman Carter filed a motion. vote was unanimous, with Mrs. Hedge-Morell absent. That, to me, is all we need to know, because there is nothing between then and now that has changed the zoning that allows for a permit of high-content alcohol to be sold at that location. If he has evidence otherwise, it would be in the public documents. I got this online at the city website, which thankfully went back far enough that that was available. So anything from then on is available. Can he show a zoning change? No. You can go online and check the zoning right now. Dr. Munster was supposed to be here. He can also verify that. There is nothing to discuss. They have a liquor license. What is the date on that liquor license that was issued in error? Is that a 5-year-old liquor license, a 4-year-old liquor license, a 3-year-old liquor license, a 10-year-old liquor license? We have that. What need is there to suspend this and to allow our neighborhood to be subjected to this kind of treatment?
Dan, what is the date on that it was sent in error?
Well, we have Mr. Mr. Stallworth here who can testify as to the dates when they, the only time that they have been issued a high-content alcohol permit. If you would like to have him.
I'd like to have him tell us. What was
And this is what I'm getting about, again.
I have it here. The application was filed on March the 11th, 2013. Zoning application supposedly on March 14, 2013. Approved March 15, 2013. I think all that's in error except for the application. Issued March 15, 2013. Nothing like that happened in 2007 when we had to go through all kind of hoops and everything. Issue date again, 3/15/2013. ABO issued 3/15/2013. Expired 12/31/2013. Please do not give this an extension. If they have a grievance, it's with the city. It's not with the neighborhood. If we have a grievance, it's with them.
And again, I think at this time, this speaks to the relevance of the information that Mr. Washington is seeking. He's seeking information that is wholly irrelevant to the proceeding that is before this board. And
Thank you, Mr. Abity.
Madam Chair,
Yes.
I apologize for my tardiness. Is the issue to proceed now or to postpone until December 16th?
Well, it is, well, the issue is not necessarily to proceed now. What residents of the neighborhood have asked is for a temporary suspension if we're going to continue it until the 16th. But as Mr. Jenkins just advised me, and I need to look at Chapter 10 real quick, if on its face it's not valid, then the board may be able to take action immediately.
That's correct.
And what is prohibiting us to proceed with this trial if the city is ready, Mr. Washington is here, and the neighborhood association is here?
Well, Mr. Washington said that there's some documents they need, but I think that if we look at Chapter 10, we may be able to resolve this pretty quickly.
Okay.
So I'm going to table the granting of the motion to continue for now. I'll let the neighbors finish speaking pursuant to their comment cards, and I'll take a look at the law real quick. James Danner.
My name's James Danner. I live at 3233 Ursulines Avenue. I'm Vice President of Fallburg St. John Neighborhood Association and Director of Public Safety. I've lived in the neighborhood since 1979. Now, the next question I have, are we discussing just the suspending the license, this argument till December, or you're looking for other?
I was just letting you speak based upon your comment card being turned in. I'm assuming it was because you thought that we were going to go forward with trial today. So if you wish to speak about the potential continuance, by all means, go ahead.
Say again, if I can speak about.
I said if you wish to speak about the pending continuance, you may speak on that matter as well.
Yes. Essentially, I think it would be an injustice to the neighborhood that you can see the number of people. Everyone here is from Fallbrook, St. John. We've come out for a reason. I've been there since '79. I will tell you, since Katrina, we have convenience stores in our neighborhood on all four corners, and alcohol is available, high content. And since Katrina, and the reason I say Katrina, we had problems with the Circle K that was at Grand Route and Esplanade. We have not had any problems with anybody else. This particular location, we have had continuous problems, and that's only when they had low alcohol. With high alcohol, we can only imagine what the future is going to bring. And I ask that this board consider the fact that there has not been high content here prior to this license that I know of since 1979. And I ask that you consider revoking the license now. And if you do defer till December, at least ask them to suspend liquor sales at that point in time.
Thank you.
Thank you.
Stephen Martin?
I would just like to echo their comments, and just it seems like there's no reason to delay it another month. You might say, well, what's another month? But we've been working on this for months and months and months since we first learned that they were selling high content alcohol. At first, it didn't seem possible because everyone said, well, that can't be. They're not zoned for doing that. So we had to look into it, and it took us a while to figure out, well, yeah, they are selling it, and two, they somehow managed to get this permit. We contacted all the various agencies, and it's taken us a long time just to get here. So now they're obviously just trying to drag this out as long as they can, and it's just enough is enough here. Let's just enforce the existing rules here. And if they want a zoning change, then they can pursue that in the ordinary fashion. Thank you.
Thank you. Miss, and it's hard to read your handwriting, Rabaya?
Good afternoon. My name is Pushpa Ramaya. I live at 1012 Creek Street, and I am a neighbor that lives across the street from S Express. I'm here to speak about the quality of life in the neighborhood with the store selling alcohol. We've had a lot of problems with the store. I bought my house in 2006. There was a shooting in 2008 where there was a gun battle between workers at the store and some folks that were trying to rob the store. There's been a lot of drug dealing going on over there over the years. Ever since they've been selling high-content alcohol there has been an increase in loitering, noise at night, people driving up, leaving their music on in their cars. The back area is used as a toilet for people. They go back there and urinate, smoke pot. The dumpster area needs to be cleaned up. 2 years ago when the store was robbed, when their ATM machine was pulled out of their store, the gentleman, I believe, that was sleeping in the store came out after the car had driven off with the ATM machine and fired his weapon, sprayed the neighborhood with, I counted 9 bullets after the car had sped off. These are the kind of folks that are at the store, spending time at the store, working at the store. So I would just ask that you reconsider continuing for them to continue on with the liquor license, which was clearly given erroneously. Thank you.
Kate Lowe.
Good afternoon. Thank you for your attention to this matter. I've been very disappointed that this store has been granted more privileges rather than less privileges given the nuisance it is for the environment, and that there hasn't been an adherence to the rules that other businesses are going through onerous processes to get liquor licenses, and the delay in these proceedings is rewarding a store that flaunted the rules. That would be disturbing enough, but this store makes me feel unsafe in my neighborhood. As Pushpa mentioned, since I've moved in, there's been at least one shooting. In 2012, a felon who was staying in the store, after much work by Detective Connolly with the police department, charged the man staying in the store with a felon illegally in possession of a firearm and discharging a weapon. The crime has not stopped recently. In fact, if you look at this Louisiana ATC records, you see that there was a drug dealer basing his operations out of the store. The drug dealer, however, didn't do his sales in the store. He would do that in a nearby parked car, but he would still spend his days in the store. This makes me feel unsafe in my neighborhood, not to mention other quality of life and debris in the neighborhood. I think that there is grounds to revoke not just the high liquor license, but frankly, this store is a nuisance to the environment and for my quality of life, my property values, and my perception of safety. If you look at crime maps, you can see a correlation between liquor sales that aligns not just with this store, but we've had particular problems with this store, but of course crime is a serious problem in the city as a whole. But there is enough crime that's associated with those spending time in the store that they should not be rewarded. So I ask that not only do you not reward the store by a continuance, but you consider revocation of their low alcohol content license as well as their high content license.
Thank you. Mr. Jeanfro, Ms. Stronger didn't take up her whole time. Do you wish to speak?
My name is Greg Jeanfro. I live at 1504 Sauvage. Basically, I'm just echoing what everyone else has said. I've lived in the neighborhood since 2006. We've had a lot of investment in the neighborhood. And at the time when people invested in the neighborhood and bought and rented their homes and have come into the neighborhood, this store, although it had its problems, did not have a high content liquor license. And now that it has it, there's obviously great concerns about that. And I don't believe that there's any hardships that can be proven for someone having a license that was not legally granted. If they obtained that property or started working there or whatever with that license, that's between them and the person that convinced them to do that. But we never agreed to that. Our neighborhood never agreed to that. And as part of the process that people would go through legitimately to obtain an alcohol permit, they would come to the neighborhood and discuss things such as provisos, do an MPP, and they would, have discussions with us, but none of those have been had. It was basically however it happened without us knowing it, and it happened without a lot of people knowing it, and it shouldn't have happened in the first place. So I just ask that, it's immediately revoked. There's no reason to hold on to it. It's not legal, and there's no hardships for the owner. They can still sell beer, potentially, because they're grandfathered in. So they just can't sell hard alcohol anymore. Thank you.
Thank you. Mr. Washington, do you wish to address this?
Yeah, but myself and the owner would like to just, make a comment to clear some things up.
Good afternoon. My name is Sandy Basant.
Your address too, please. Your address?
Of the business is 2703 Ursulines.
And your personal address for the record, please.
7221 Arbor, A-R-B-O-R. I became the new leasee as of January 2013, and since then I have made some improvements to the business establishment. Some of the things that concern the neighbors, I understand why it may concern the neighbors. Some of those things, such as the shooting, though, which when the person was living there, whatever, that was before me. That was in 2012. My lawyer had also at some point, and he doesn't have them with him, but had showed crime maps. The crime has not gone up, and I understand what the concerns may be, but I have told the neighborhood association that I'm willing to work with them. Also, I got the permit not once, but twice. I had no idea that what was going on, that you were and were not supposed to have high alcohol content. All I did was apply, and the city gave it to me, as I said, not once, but twice. And since then, some improvements have been done to the building as far as landscaping, things of that nature to help to fit in with the neighborhood, and I'm willing to do more, but I have a problem with the license being suspended because I've already purchased alcohol, and I have to sell it in order to keep the business going. So that's the problem I have with it being suspended, and like I said, my problem with it being revoked is that it wasn't anything on my fault. It was just given to me after I applied, not once but twice. And I also have petitions here of multiple people that live in the neighborhood that have signed saying that they understand that we sell alcohol to adults and they feel safe and they have no problem with it.
Well, that would be evidence that should be brought forward at the hearing, at the entire hearing
Right.
of the matter. We don't need that today.
Yes,
Thank you.
ma'am.
Can I ask
Mr.
a
Washington,
question?
did
I mean, I'm just curious, when you say not once but twice, you mean it was renewed, or what do you mean by that?
Exactly. She was initially issued, applied for, and it was issued, and the date of her first permit was August of 2013, and alcohol sales began on that date. Then when it came time for renewal, she renewed her permits, and the permit was renewed, and she continued to sell alcohol for another 1 year period, starting the second year period that we are on now. Now, she has a substantial, I mean, if you go in the store, she has a substantial stock on the shelves of high content alcohol. And again, when she took over the business, and if you look at most applications, if not all, when the applicant applies, and I've spoken to personnel in the Department of Finance, they check both high and low, whether they can get it or not. That's just a standard way, is my understanding, that they apply. And she did that as a new owner, and not knowing that, the difference was that's the standard way you apply, and she was given both permits. So I want to make it clear, there was no intent on her part to deceive. I mean, it's being kind of described in a way that she's a bad person, that she did something. She did not. And right now, she has a substantial stock of alcohol. And that's since taken over. And these crimes, these bad crimes happened before everything that would describe the shootings. I'm aware of the two shootings because I worked with the prior owner to try and work with the neighborhood, but he got sick, and it didn't in 2009. I'm aware of the shootings. I'm aware of this and that. But that was prior to her ownership. But since she's taken over, she's painted the building. she's made improvements to the interior. She has fresh fruit all, as soon as you come in. She has made, in my view, some substantial improvements. And when you say landscaping, it's not just planting a few trees. It's all along the side. There's substantial planters with trees, et cetera, et cetera. And we met with the neighborhood association just last Monday to start the process and to breach and make contact with the process of seeing if we can do the zoning change and what more, and to work with them on what more they want done. So we're not here trying to push through something. We realize that there's an issue, about the alcohol permit. And concerning Ms. Besant, this is her business. She's also a full-time pharmacist at a local pharmacy, chain pharmacy. She's not a person who's taken up this business lightly. So I just want to clarify that this is what we're here. I think it's fundamental that when a petition is filed, I think it's fundamental that you can receive requests. You're entitled to request and receive, at least as a starting point, your file. I think it's just basic that that you can receive your file and not have to come here and guesstimate and estimate of what it might contain and what might be relevant. I just think it's fundamental that at a starting point that the person who's being threatened with severe penalties just has a basic right, just the basic fundamental information to see what happened and to find out what is the error, who made the mistake or error, because it's one of the factors. One of the factors is that it's being alleged that a mistake or error was made. Well, I need to find out if a mistake or error was made, because that has to be proven by the city.
Suppose there was a mistake, an error that she received the permit, but does that give her the legal right to continue to hold it if she's not grandfathered in?
Well, I can tell you this.
It's either a yes or no.
I think the issue is, in one case reported case that I read, one of the factors the court considered was, and in this case, the city did not put forth any information that a mistake or error was made.
Right, but when you came in this and you argued that it's either grandfathered in 5 or you alleged 10. But if it falls within, say, that 1, 2, or 3 year period, would you then assert that there's no legal right to assert the grandfather clause?
If
indeed she received the permit March 15 of 2013,
mm-hmm.
then that doesn't fall within the grandfathers.
But I'd have to look at what the use was.
Well, no. What you argued it was the grandfather should be grandfathered in. So what I'm saying is that if indeed that's the case, hypothetically, if that's the case, you would argue as a lawyer then there's no legal right or cause for the permit to exist because there's no permit, correct?
Well, no, I'd have to see what the prior owner did. What did they do? Did they sell high content alcohol? What was their use? What were the permits issued? Because I remember representing the prior owner in 2009. The same thing happened. He was issued a high content permit in 2009. So one of the things I would have to look at: did he stop selling? Did the use? So that put the city on notice in 2009, the written notice to start the period. Then the question becomes: did he stop selling, or did his use continue such that the use continued for a period of 5 years?
But are you arguing that then, if indeed the other individual had it, she's grandfathered in through his grandfather?
Oh yeah, you can. Yeah, it's clear. You look at.
We talk about the tacking. I know that, but the point is, her permit. All we have to look at is March 15, 2013. Do you contest that?
Yes, I can look at the prior permittee and their actions and what they were issued.
I think the city has the documentation, and he pulled up. What was the date that they alleged they got the permit? I have it written down. It's March 15, 2013. You found it? Okay. Well, actually,
I just want to, Mr. Jenkins, while we're trying to, so we're got some other information going on in the computer right now, but I mean, I think it should give you pause that every time that you're asking a direct question, and you said yourself, this is a yes or no question. You post, I believe, a hypothetical, and of course, you've got an answer that was non-responsive to your question.
Yeah,
I think that ought to give you pause as to what we're dealing with here. That we are dealing, again, all this other discovery issues, and I'm sure that Mr. Stallworth would be happy to tell you that any permittee can come down and get a copy of their file, that is not something that is, that's information that's readily available to them at any point in time. Again, this is a very simple issue as to whether this permit was issued in error. Mr. Washington, as he stated, we realize there's an issue with this permit, and the issue he realizes is I would posit is that he knows that it was issued in error. This is a lot of window dressing for what is a relatively simple issue.
I like
Mr. Jenkins wants to take a 5-minute recess on this issue because there are some documents that we want to get from the gentleman in the audience.
Can I ask a question before we take that? Madam, when you bought when you obtained this business, did they have a high alcohol content license at that time?
Not that I know of.
And so all of a sudden you get a permit.
No, I applied. It wasn't all of a sudden I applied.
You applied particularly for a high alcohol content permit.
I applied for alcohol content, and as my lawyer said, I applied for both. It wasn't just one or the other, or specifically this one or that one, high or low. I just applied for both.
Okay. All right, thank you.
All right, thank you. Before we take a brief recess, are there any other matters that we can do away with quickly so that we don't keep people sitting here?
Well, we have the
Ed, we're going to pass on yours. Come right back to it.
The S Express food store issue. Is that okay?
Yes, that's fine.
Okay. Can we go back on the record, please?
Reestablish your quorum.
Yes, please.
Michael Scott, Robert Jenkins, Clifton Davis, Derek LeBeau, Samuel Odom, William Schultz, and Jerry Spear. This quorum has been reconvened and reestablished.
Thank you. Based upon the information that has been provided, I'm sorry. Mr. Washington, you want to come back up? It is our understanding that this establishment is currently zoned RD-2. They had applied for a zoning change that was denied. we looked at section 10-110 of the code that talks about issuing alcohol beverage permits. And it says the Department of Finance shall not issue permits if the location does not comply with requirements of the comprehensive zoning ordinance of the city. Therefore, it is our position, at least is my position, that there really is no permit because the city could not, it specifically says in the code, it shall not issue a permit. So therefore, this establishment, while it can serve beer, it cannot serve high-content alcohol. There is no permit to do so. Does anyone up here agree with my position on that as it's read?
I agree with as it's read because I even go further and say they had no legal right or legal cause for it because there's no permit that exists legally.
So we don't have the option to revoke it or suspend it because there is no permit.
Okay,
Therefore, they cannot sell any high content
can I
alcohol.
reply? I just want to.
You may.
Okay, I mean, the petition that's been filed, well, first is a fundamental thing, and this is just one, I think in all cases, you know, when you're sued with a petition where there's severe penalties, you're at least entitled to some initial basic information. But, you know, I just think that in any case. Now, number two, the city code in the city alleges in this petition that there's been a mistake or error in the issuance of a permit. So I would like to elicit evidence of what the mistake or error, who made the mistake or error, because I think that's a necessary element to be established under the code in order to revoke the permit. The allegation is that the code says if there's a mistake or error in the issuance of the permit can be revoked. So I'd like to put on get some testimony from the director and maybe from the Department of Finance to have the city prove that element of the code of the requirement for revoking the permit.
Well, this is
okay. Well, we can accommodate if
we had discussed. This is, I'm assuming, not the only issue before us, Mr. McNamara. In your petition for damages, are you also seeking to find that this establishment is a public nuisance? And
we have not filed a nuisance complaint. No, the sole issue, I believe. Let me see
I thought that there was an allegation of public nuisance. I'm sorry.
I think if there is, that's a standard boilerplate language he puts in all his petitions. I mean, it is. I mean, you read all his petitions, it's always going to have that language.
Yeah.
I'm just looking at my cheat sheet for the hearing where it says determination of the existence of a public nuisance on page 1.
Yeah, if you actually look at the specific provisos in chapter, the specific violations listed in paragraph 4, which we've given notice for, it is the 10-157. A18, mistake on part of the administrative official or employee or on the part of the applicant in connection with the issuance of an alcoholic beverage permit for which, absent the error mistake, the permit would not have otherwise been issued. So that is what we've alleged. We didn't allege any additional nuisance issues. So the sole thing before the board at this time is the permitting issue.
And that's my understanding.
Well, actually, I would say, I think there's some language which kind of which is more boilerplate, but the specific violations that we've listed and for which we have given notice is the permitting issue. But I mean, as to Mr. Washington's statement as to whether it seems now that he's indicating that there is an error in the permit and what the relevance of what particular person made that error. I mean, that's not relevant to the proceeding. The fact remains that if there was a permit that was issued, it was issued in error, and who that was or why it was, I don't know that that's particularly relevant. The fact is that it was an error and should not have been issued.
I agree. I mean, that's my position. Is that's how I'll read 10-110.
And I'm sorry and I don't mean to cut you off, but you know, this board has, of course, I think under the city code, the authority to bring any matter sua sponte.
Right.
But just as we had discussed earlier, when you were asking about people who wanted to comment and intervene in a particular case, any person has the standing to do that.
Any comments from the board?
No, I think we've said it.
I believe then I would entertain a motion.
As it relates to this hearing, I move that as a matter of law, they had no right, there's no legal permit, so therefore, this location cannot sell high-content alcohol, and I move that if any permit exists, that it should be withdrawn.
Second.
All in favor?
Aye.
Any opposed?
That's correct.
Well, can I get a clarification? Oh.
Yes, sir. That this is, as a part of that motion, that this action is immediate and not to be delayed.
Can I get a clarification on that? Because the board rules say that the judgment is not effective for 30 days after signing. So,
But I think in this instance, it's not necessarily a judgment as to revocation of a permit. There is no permit based
well,
upon.
she physically has a permit.
Right, but whatever permit that allegedly she has was illegally issued is not valid.
Mm-hmm.
So therefore, we can move with to take the court with all deliberate speed and go forward.
And in all fairness, I mean, she has a substantial stock, of
right, but
alcohol
as a lawyer, you then can say, hey, you talked about detrimental reliance. You'd have to bring that to another forum to do that. But as we're allowed here legally, there's no permit that exists that she can sell such alcohol.
And
I mean,
so,
she knew she needed a zoning change because it was applied for, whether it was by this owner or the prior owner. They knew a zoning change was necessary.
she had no knowledge that she needed a zoning change. She's a new owner, and she applied for this permit, and she had been operating for going on her second year, and is operating without any knowledge until this petition was served on her.
But that's
and all I'm asking is that under the rules that it says that the judgment is not effective for 30 days,
but we
you're
can't
just suspending a permit that exists.
You cannot let someone serve alcohol that legally can't have it. I mean, as a result of that, the police could go in there and arrest her.
I mean, after the 30 days when this judgment becomes effective.
No, but there's no license.
There's no
permit.
permit. Section 10-110 specifically says, the Department of Finance shall not issue permits if the location does not comply with the comprehensive zoning ordinance of the city. And it doesn't. It's zoned RD2, and you can't be zoned RD2 and get an ABO permit.
But she physically has a permit.
But it was.
It can't be issued.
Okay.
Counselor.
Ed, you understand legally. We as lawyers, we understand what you're saying, and there are other remedies if you don't agree with us. But legally, if she sells alcohols without a legal permit, she's subject to be arrested.
Okay.
The other concern, if I may, Madam Chair, is in terms of the costs associated with the purchase of the high volume and low volume alcohol. Seemingly, from the board's perspective, that might be something that you, as a counselor, will take issue with the issuing authority who issued the license, or whatever the appropriate department is, as it relates to the loss or the potential loss in terms of her not being able to sell alcohol.
Your suggestion that I get a monetary judgment against the city?
No, he's not saying that. He's saying that you brought up the fact about other issues, and as a lawyer, you can counsel her on what she may or may not do. That's what he's saying.
Correct.
Okay.
Thank you. Mr. Caulfield, I have a request to speak card. Do you still wish to speak? Thank you.
I think we have one more speaker.
I'm sorry.
I'd just like to say, just for future reference, this should have never gotten this far. It should have been handled administratively. They should have looked at the law and said, we didn't issue you a legal permit, and therefore it's being withdrawn. Go see zoning and get a zoning change.
Thank you, Mr. Avity. All right.